Hello everyone and a very good morning. As you can see behind me, the topic that we are going to discuss today, section 89 and 90 of the Companies Act. A new section, new things and a little confusing also. So in this video, I'm going to clarify everything that relates to these, beneficial owners or significant beneficial owners. And I hope by the end of the video, you are actually able to understand everything relating to that. And if it helps you, do leave a like and a comment so that we know that the video actually helped you in some way. So before we actually go into what is beneficial interest, let us understand the benefits that we derive from the shares. When I am the owner of the shares, can I say I have certain benefits that I get from these shares? Yes or no? If I am the owner of the shares, I am definitely going to derive some benefits from the shares. Ma'am, benefits like dividend, rights, bonus, yes or no? So that is what we mean by benefits, right? What is beneficial interest? In fact, if you have already attended seen the video where we had discussed the definition of members, there I had already given you this concept also. So what is this beneficial interest or beneficial owner? It means I am not registered as a member of the company, right? I am not registered as a member of the company, but I enjoy the benefits over the shares, on those shares, right? I repeat again, what is beneficial owner? It means, or beneficial interest, it means I am not registered as a member, but I get the benefits on those shares, right? I am not registered as a member, but I get the benefits on those shares. This is beneficial interest. This is beneficial. Ma'am, can this happen? Yes. In fact, in the definition of members, I had given you the concept of depositfree, where in the books of the company, the depositary, in the register of members of the company, the name of the depositary is mentioned. Further, obviously the depository is not going to keep the shares, it will give it to the public, the outsiders. In the registers of depository, the public is named as a member. But whatever shares are held by the depository or whichever is named in the register of members of the company for the depository, the benefits of these shares are not received by the depository, but it is given to those persons who are named as members in the register of depositories. So this public, their name is not entered in the register of member of the company, right? This public, their name is not entered in the register of members of the company, but they derive the benefits on the shares. So they are known as the beneficial owners or beneficial interest holders. I hope this is clear to everyone. Yes, let's take another case. If you remember anything about what you studied in foundation, in partnership firm, let us say A, B, C and company is a partnership firm, right? And A, B and C are partners of the firm. Now, in fact, this we had also done in who can or cannot become a member of the company. This is also done there. So now this ABC and company wants to purchase the shares of X Limited, right? Now, I repeat again, ABC and company is a partnership firm with AB and C as partners of the firm. Now, ABC and company wants to purchase the shares of X Limited. Can ABC and company in its own name purchase the shares of X Limited? No. Why? Because a partnership firm, because it has no separate legal entity, it has no legal existence, it cannot acquire the shares in its own name. However, can A, B and C acquire the shares as joint holders? Yes. They can become the joint holders of the shares on behalf of the firm. But the firm cannot be registered as a member, except in case of a Section 8 company where even a firm can be a member. Otherwise, it can only be that the partners can be joint holders, but the partnership firm cannot take up the shares. So now ABC are holding joint holders, they are the joint holders of the shares of X Limited on behalf of the firm. So whose name appears in the register? ABC. But who gets the benefits of the shares? Who gets the benefits of the shares? ABC and company. So this is, can we say that ABC and company holds beneficial interest in the company? Yes, ABC and company holds beneficial interest in the company. Did you understand this? Yes. So ABC and company holds beneficial interest in X Limited. So what is beneficial interest? I am not registered as a member of the company, but whatever benefits are there on the shares, I have a right on those benefits. I get those benefits. I hope it's clear. Yes. I'll give you another example. Basically understand here, 3 people are required to make a declaration. The member, the beneficial owner and the company. All the 3 of them are required to make declarations. So before we go into this, let us take another case. X Limited started a subsidiary, Y Limited, right? X Limited started a subsidiary, Y Limited. The 100%, let's say Y Private Limited rather, okay? So my pen is gone again, shit. So let us take this as Y Private Limited, okay? X Limited is the holding of Y Private Limited. So that means, can I say Y Private Limited is the subsidiary? Yes. Now it is a wholly owned subsidiary. What do I mean by wholly owned subsidiary? All the 100% shares are held by X Limited. Correct? Okay, you must have heard, no, wholly owned subsidiary. Yes, one is subsidiary, one is wholly owned. Subsidiary is more than half, but wholly owned means 100% shares are held by the holding. But then Y is a private company, and being a private company, it would need how many members? Minimum 2 members, correct? So being a private company, it would need at least 2 members, but the entire share is held by X Limited. How is it possible? That can only happen in case of an OPC. So what X Limited did was, they held 99% of the shares they held, and 1% of the shares was held by the director of X Limited, Mr. X, on behalf of the company, right? So 99% of the shares was held by X Limited only. But 1% of the shares was given to the director in the name of the director to maintain the minimum membership, right? So 1% of the share was given to the director, Mr. X, to hold it on behalf of X Limited. So can we do this? Yes. The Act allows a company to maintain the minimum number of members to hold the shares on behalf, to name someone as a member on their behalf. The shares will actually belong to X Limited, but just to maintain that minimum number of members, they are holding it in the name of the director. So this is allowed. Act says that the investment should be held in the name of the company. But in some cases, where to maintain the minimum number of members, they may appoint someone, or they may give the shares to someone else to hold on the behalf of the company to maintain the minimum members. So here 1% of the shares are held by Mr. X. So in the register of member, who is the owner of the shares? Mr. X. But actually the shares belong to whom? X Limited. So can we say for this 1% share, X Limited is the beneficial owner, correct or not? Yes. So X Limited is the beneficial owner for that 1% share. Why? Because though Mr. X's name appears in the register of members, but it is X Limited who actually enjoys the benefits of the shares. I hope it's clear to everyone. Yes. Now, what declaration are we talking about? Declaration has to be made by X Limited. Declaration has to be made by X, and declaration has to be made by Y Limited. Right? Declaration has to be made by X Limited, declaration has to be made by X, and declaration has to be made by Y Limited. Now listen carefully. I am actually going into this section now. If a person is named as a member in the register, even though he has no beneficial interest in the shares, or if a person is not named as a member but holds beneficial interest in the shares. So I hope you've got it. Yes. So a person is named as a member in the register even though he has no beneficial interest. This is what? Mr. X. A person is not named as a member but holds beneficial interest in the shares. This is what? X Limited. Within 30 days of acquiring such shares, has to make a declaration. Declaration, that means I am not the beneficial owner though I am the member. This declaration in MGT 4. Right? In MGT 4, he must make a declaration within 30 days from the date he acquires the shares, and here also within 30 days from the day he acquires the interest. Which interest? Beneficial interest. He must make a declaration in MGT 5. Right? Now this declaration is made to whom? Company. Which company? Y Limited. Right? This declaration is made to the company. Now as soon as the company gets this declaration, the company will make a note in the register. Why? Because the company should know that who is actually going to get the benefits of the shares, and file a return in MGT 6 with the registrar. Right? So the company also has to make a declaration, and the person who is holding the interest or the person who is named as a member, all the three of them have to make declarations. So has to file a return or a declaration to the registrar. Is it clear to everyone? Now has to file a return in MGT 6 with the registrar. I hope it's clear to everyone. Yes? If the beneficial owner, right, fails to make the declaration, he shall have no rights over the shares. That means if he fails to make the declaration, his rights over the shares are lost. That means he cannot claim from the company his rights over the shares, that is the dividend, rights, bonus, whatever. He cannot claim any rights over the shares. But it shall not absolve the company of its liabilities. Now what do we mean by this? I just said that the beneficial owner loses his rights. So the company will say, okay, the dividend belongs to me, I don't have to pay. No. Company, your liability to pay is not coming to an end. The right of the beneficial owner to claim his rights over the shares has come to an end. He cannot claim anything from the company, but the company is still liable to give the rights. He will give it to the member. He cannot say, I am not liable. The company's liability does not come to an end. The beneficial owner cannot claim from the company, but the company is still liable to give those rights to the member. Is it clear? So, the beneficial owner cannot claim anything from the company, But that doesn't mean the company has no liability. The company's liability is still intact and it is still liable to give the rights to the member. I hope this was clear to everyone. Yes. So can we move on to the next section, section 90, which talks about significant beneficial owner. Now, significant beneficial owner as given under section 90, read with companies significant beneficial owner rules 2018. Generally, you have seen all the rules in 2014, but this section was only not in force before 2018. So how can the rule come into force before that? So that's the reason it is 2018 and not 2014. Now, what do we mean by a significant beneficial owner? What do I mean by a significant beneficial owner? A person whose name is not entered in the register of member of the company but has the beneficial interest over the shares, right? Whose name is not entered in the register of member of the company but who has a beneficial interest in the shares. Interest includes interest through layers, right? I'll explain everything what it means. We will take an example to understand it, so don't worry. So I repeat again, what is a significant beneficial owner whose name is not entered in the register of members of the company but who has beneficial interest in the shares? Beneficial interest, I've already explained this concept, you know it, right? Interest may go beyond a layer. This is something you need to understand because when I give you examples, this concept will come. May go beyond a layer, right? Now listen very carefully. What is a significant beneficial owner? If an individual, we are not talking about a company here, we are only talking about an individual, right? If an individual alone, मैं अकेला, everything I am only, or together, that means counting my holding and your holding together. That means I alone or I and you together, or through any person or trust. Through any person or trust, including a person or trust resident outside India, right? So I repeat again, if an individual on his own, in his own capacity or together with someone else or through, that is layer, any person or trust, including a person or trust resident outside India, holds beneficial interest in the shares, which is at least 25% of the shares of the company. And when they say 25%, what they have given is 25% or such other person. Don't worry, I'm going to explain everything to you. Of the shares of the company or the right to exercise control or the actual control. Now please understand, if the company has a share capital, you hold 25% of the beneficial interest of their shares, then I know 25% of the shares you're holding, you have beneficial interest. But if the company does not have share capital, then I don't have the criteria of the shares to determine whether you have beneficial interest or not. There, obviously, it will be as per the control. The right to exercise means you have the right to exercise it or you are actually exercising it right now. Then we call it as significant beneficial owner. So if your interest in the shares of the company is at least 25%, then we can say that you are a significant beneficial owner. Is this clear to everyone? Yes, I repeat again, if you hold 25% of the beneficial, at least 25% of the beneficial interest of the shares, in the shares, or the right to control, or you are exercising control, then we can say that you are a significant. So what is the criteria for significant beneficial owner? 25%. However, as per the rules, the percentage is 10%. So which one we follow? Obviously there are two things conflicting, harmonious construction. So if I follow 10, I am not going against anything, but if I follow 25, I am going against the rule. So how much? 10%. So to become a significant beneficial owner, your holding must be at least 10% of the beneficial interest of the shares or control in the company. Is it clear to everyone? Is it clear to everyone? Yes. Now I'm going to give a few examples which I want you to solve before I actually give you the answers. Let us say Z is the, okay, Z holds 12% shares of Maximum Limited as the sole shareholder, right? Then C Limited holds 20% of the shares of Minimum Limited, right? K holds 75% of shares of C Limited, and M holds the remaining 25% of shares of C Limited, right? Now the third case, K is a trustee of a charitable fund, charitable trust, which holds 20% of shares of Charity Limited, right? R, Z, K, M and IO. Again I have written K. Okay, chalo, K significant beneficial owners. So I am giving you 5 minutes. I want you to solve it before I actually give you the answer, and you should do it before I give the answer. Finished? Yes. So the first one, Z, holds 12% of maximum limited as the sole shareholder. I guess most of you would have got the answer as a yes because he's holding 12%. But the answer is no, because he's the shareholder of the company. Please understand, to be a significant beneficial owner, I should not be named as a member, right? Okay, C to the next one. C Limited holds 20% of the shares of Minimum Limited. K holds 75% of shares of C Limited, and M holds 25% of the shares of C Limited. So we have here C Limited and we have here Minimum Limited. Now 20% of the shares of Minimum Limited are held by C Limited. Now K and M are the members of C Limited, holding 75% and 25% shares of C Limited respectively. Now can we say that out of this 20%, 75% is indirectly held by K? Yes. So K is holding how much? 15% indirectly of the shares of Minimum Limited. So can we say he is the significant beneficial owner? Yes. Now we can say that M is holding the remaining 25% of 20% indirectly, right? 20% because only 20% holding is there. So which is equal to 5%, which is less than 10%. So he is not a significant beneficial owner. Then K is a trustee of a charitable trust which holds 20% of shares of Charity Limited. That means K is indirectly holding 20% of the shares of Charity Limited. That is, he is holding the beneficial interest. So can we say he is the significant beneficial owner? Yes, he is the significant beneficial owner. I hope it's clear to everyone. Now let us understand this layers wala concept. Mr. A holds 100% shares of X Limited, right? X Limited holds 65% shares of Y Limited, right? Can I say Mr. A is the significant beneficial owner of Y Limited? Yes, because he is indirectly having a beneficial interest of 65%. Is it clear to everyone? So now, I hope this is clear to everyone. So now what section 90 says is that such person, when we say such person, which person are we talking about? The significant beneficial owner shall make a declaration to the company. What declaration? Specifying his interest and ownership, right? Specifying his nature of interest. What kind of interest he has in the shares? What kind of beneficial interest he has in the shares? Ayo, what I have written? I'm so sorry. Companying. I'm so sorry. It is company. Sorry. So, shall give a declaration to the company specifying the nature of his interest. Now, what will the company do? The company will in turn maintain a register, right? The company will in turn maintain a register. So, I repeat again, such person. When I say such person, I am talking about the significant beneficial owner. Such person shall make a declaration to the company specifying the nature of his interest in the shares of the company. Now, the company shall maintain a register where the name, address, the date of birth and other details of such person shall be given, right? So, the company shall maintain a, why such declaration is made? So that we can know who is actually having a control over the company. Why these declarations are made? So that we can know who actually has that control over the company. That's the reason such declaration is made. So, the company shall maintain a register specifying the name, address, date of birth and other details of such person, and this register shall be open for inspection. This register shall be open for inspection by the members on payment of fees. So that means the members can inspect this register. They can inspect this register by paying the fees, and it shall also file a return with the registrar, obviously specifying the name and other relevant details of the significant beneficial owner. So I repeat again, who is a significant beneficial owner? If an individual, please understand, we are not talking about the control of a company here. If an individual, he is holding the shares in he alone or together with another person or through, that is through layers also, if he is holding at least 10% of the shares or control or right to exercise control or the actual control of a company, he is a significant beneficial owner. But section says 25%, rule says 10%. Such person, that is such significant beneficial owner, has to make a declaration to the company specifying the nature of his interest. The company will in turn maintain a register where the name of such person, address, date of birth and other details will be given, and this register shall be open for inspection by the members on the payment of the fees. Again, also the company has to file a return with the registrar specifying his name and other details as are relevant to the registrar. Now, the company shall take steps to identify. The company shall take steps to identify a significant. Okay. It's gone again. So the company shall take steps to identify a significant beneficial owner and require him to follow the provisions of the Act. What does this mean? This means that if a person who is a significant beneficial owner has not made declaration to the company, then the company should take steps to recognize him. Right? I repeat again, a person who is a significant beneficial owner has not specified his interest to the company, then in that case the company has to take steps to recognize. So now what we are going to discuss is where the significant beneficial owner has failed to make the declaration. Right? Now what it says is the company may give notice to any person. Now when we say notice to any person, this person may or may not be a member. Right? This person may or may not be a member. So the company must give a notice to any person who the company believes. So please understand, this provision is applicable when the significant beneficial owner has not made the declaration. So the company must give a notice to any person, whether the person is a member or not, who the company believes is a significant beneficial owner, or so he is a significant beneficial owner or has knowledge of a person who is a significant beneficial owner or any person who has it. That means you are not a significant beneficial owner of the company, but you know a significant beneficial owner. So the company can give you a notice that please tell us about him. Or you know me and I know a significant beneficial owner. So the company can give you a notice to give information about me. So if the company knows that you are a beneficial owner or knows that you know about someone who is a beneficial owner, or you know me and I know about someone who is a which beneficial? Significant beneficial owner, or was a significant beneficial owner any time during the past 3 years from the date of notice. That means from the date of notice given, I was aware from the date of notice given in the past 3 years, any time you were once a significant beneficial owner. Why this concept? Because please understand, this section is new. It was not there earlier. So in the preceding years also, if I knew someone was a significant beneficial owner, I have to ask them also to make a declaration, right? So if, let us say, the significant beneficial owner does not make a declaration, the company can give a notice to any person who is a significant beneficial owner or was a significant beneficial owner in the past 3 years at any given point of time, or knows about a significant beneficial owner and is not registered as such. That means he was or is or knows about a person who is a significant beneficial owner, but he is not registered in the records of the company, not registered as such. I hope this is clear to everyone. Now, once this notice is given, within 30 days, the concerned person must give the information. Within 30 days, the concerned person must give the information. Is it clear to everyone? Yes. Now, if the information is not given, what happens is, if the person does not give any information, so if no info is given, or whatever he has told us is insufficient, or the information is insufficient, right? So I had asked him to give me information. Now he has given me information which is insufficient, or he has not given me any information. Then in that case, within 15 days from when? From the last day specified in the notice. That is, I have given him a notice that by this time please reply, right? By this time please reply. If within that time he replies or he does not reply, then within the next 15 days, I will file an appeal to the tribunal. I will file an application to the tribunal. That, see, this is the case. I have tried to, gather all the information, but he's still not giving me, or he's giving me insufficient information. Now, within 60 days, the tribunal will pass orders restricting the rights on the shares, right? So within 60 days from the date of application, the tribunal will pass orders restricting the rights on the shares, but you have to hear me out. You can only pass orders after hearing me out. So after giving an opportunity of being heard to both the parties, to the company and to the concerned person, they will give an opportunity of being heard, and after that, within 60 days from the day application was filed, the order will be made to restrict the rights on the shares. So I repeat again, if I know a significant beneficial owner, or I know a person who was a significant beneficial owner any time in the past 3 years, or I know a person who knows about a significant beneficial owner, and such person is not registered, then I will give a notice to that person that please inform. If within 30 days they inform, fine, or they give information which is sufficient, fine. But if they don't, I will file an application within 15 days to the tribunal. The case will not be pending in front of the tribunal for more than 60 days. That is, within 60 days, the tribunal will pass an order restricting the shares. Now, tribunal has passed an order, so I am, restricting my rights. I am going to sit and cry, my shares rights are gone. No, I'll go and file an appeal within 1 year. So, the company or the person, whoever is aggrieved by the order of the tribunal, right? Whoever is aggrieved by the order of the tribunal may apply for relaxation or removal. That means what? Please completely remove the restrictions or give us some relaxation in the restrictions. So you can file an application, either completely remove all the restrictions or give us some relaxation in the rights. Yes, within the restrictions within 1 year from the order. So if any person is aggrieved by the order of the tribunal, he may apply, that is the company or the person, whoever is aggrieved, may apply for either completely remove or give us some relaxation in your orders within 1 year from the order will apply to the tribunal. So Is it clear to everyone? So whatever orders are passed by the tribunal restricting my rights, I have a right to apply again to the tribunal that please remove the restrictions or give us some relaxation. And when this application is not filed, if no application is filed within 1 year, these shares will be transferred to Investors Education and Protection Fund. Right? If no application is filed for these shares within 1 year, then it will be transferred to Investors Education and Protection Fund. Is it clear to everyone? Yes. So I'll just do the recap of the entire thing. Beneficial owner means I am not registered as a member, but I hold interest in the shares. Right? Interest includes an interest in a right to exercise the rights on the shares, and or a right to participate in the dividend. That means I get the dividend or I get the rights over the shares. Here declaration is made by both the persons we are talking. If the person is a member but has no beneficial interest in the shares, or if a person is not a member but has a beneficial interest in the shares, must apply to the company in MGT 4 for the member, MGT 5 for the beneficial owner within 30 days. The company shall in turn file a return with the registrar giving a detail about these people, these persons. Is it clear to everyone? Yes. Now, when the such holding is 25% as per the act and 10% as per the rule. So 10% will say, when I am not registered as a member but I have beneficial interest in the shares or controlling the affair, controlling the affairs of the company to an extent of 10%, I become a significant beneficial owner. This can be by me, and here we are only talking about individuals, by me alone or together with another person or through layers. If I hold 10% of the beneficial interest in the shares or I hold 10% of the control in the affairs of the company, then I am a significant beneficial owner and I have to inform the company about it. The company will maintain a register specifying my name, address, date of birth and other details of my ownership, and also file a return with the registrar. This register at the company's office shall be open for inspection by any member on the payment of a fee. Now, company, if someone has not informed the company but that I am a significant beneficial owner, but the company knows about that person, the company should take steps to recognize them. So, if a person has not been registered as a significant beneficial owner but the company knows about it, the company will give a notice to that person. Or if the company knows about any person who was a significant beneficial owner in the past 3 years, anytime, or knows about a person who has knowledge about a significant beneficial owner, to any of such persons, the company will give a notice that please give us information. Within 30 days, the information must be given. If the information is not given within 15 days from the last date of the notice, the company will file an application to the tribunal. After giving both the parties a chance to be heard, the tribunal will pass orders within 60 days restricting the rights on the shares. And if I am aggrieved by these orders, I can again apply to the tribunal to either remove it or give us some relaxation. I hope this section is clear to everyone. I hope this video helped you. If it did, please leave a like and a comment. Thank you so much. Happy learning and stay motivated.